Welcome to the Power of Offense with Keith and Rodney, and I'm your host. And right below me on your screen is Rodney. And
Greetings.
Today we're going to discuss this suit that was filed by Jessica, aka Miss Average at Best, against Kevin Samuels. Now, for those of you all who haven't seen the first video, we're going to drop a link in the description box for you to check out the first video that we've done on this subject matter. Now, this particular video is a little different. Reason being is that we have new information. As you can see on your screen, we have a video that was put out by Donovan Sharpe. It was an interview between him and Kevin Samuels, of which we're going to listen to obtain more details about the suit that Jessica filed against Kevin Samuels. And before we get started, let us give you our disclaimer that we are not attorneys. We're not here practicing law nor teaching you law. Here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. All right. So we're going to get to it and let's unpack this. And fair use. And here we go.
So give us, I guess, give everyone the Reader's Digest version on what has happened, whatever you can do, legally speaking. Obviously, if this really is a legal thing, we don't want to.
Well, let's just put the rubber put the paint where it is.
Let's do it.
I have a concept called eternal sevens. We and red pill.
Wow.
We all know what this whole thing is when women hit the wall, and all this other thing. In general, happy people, happy women move in a certain kind of way.
Right.
And unhappy women, especially women who are bordering on narcissists, there's a lot of stuff going on with undiagnosed mental illness, and online.
Very true.
You can start seeing it kind of play itself out. So what's at the base of all this is this woman actually ran afoul of you.
Yes.
Long before I even knew who she was. And I did a show back in the summertime, people.
Yep.
In the summertime, where she came onto the show and proceeded to try to talk about how she was high value and about the high value men that she knew. And if anybody watched my show.
All right, I'm gonna stop right there just to let everyone know. Kevin is referring to two lawsuits. He actually has two lawsuits against him. So right now, the woman that he's referring to is a different woman. It's not Jessica, aka Miss Average at Best. So we're not dealing with that particular lawsuit. Now, we would love to review it. However, we don't have any information about the other lady. All right. So if anybody has any information concerning her, we would love a copy of her lawsuit. Anything like that, again, please send us an email, and we're going to drop matter of fact, we're going to put our email down in the description section of this video also. All right, let's keep going.
Show, we had an interview segment, and honestly, she made herself look pretty poor. She didn't have a very good showing. That was not my fault.
Well, here's the thing, Kevin. I think what everyone needs to know is in her little video with her little lawsuit against you, she says it's your objective is to humiliate these women. No, as a matter of fact, they actually do it to themselves. Anyone who's paying attention to your show knows that all you're doing is giving them enough rope to hang themselves with, right?
Now, let me stop right there. I must say that personally, I agree with what Donovan Sharpe is saying right there, in the sense that, these women are volunteering to speak to Kevin. You know what I mean? They're participants. They choose to speak to him. They volunteer information. Kevin just simply asked them questions, and these women, they just comply. So I do agree with what Donovan Sharpe is saying right here.
But the other guy said something I believe is important. He said, I don't know if the lawsuit said that I guess the accusers are saying that Kevin's intent is to make them look bad. You know what I'm saying? I think they said that right before. So it depends on, again, what they're claiming.
Right.
But if and it's all going to depend on how it goes. But if they're claiming that his intent is to try to embarrass these women for profit, in addition to using their image to profit from that, you can volunteer all day. But yeah, it's kind of tricky. It's just, I don't want to do too much speculating.
Right.
We don't have facts. Yeah, we don't have, just go ahead. My bad.
Right. No. I understand what you're saying. And actually, I agree with what you're saying. My only thing is, to me, I think it's difficult to prove it just because of the fact that Kevin asked them questions. You see what I'm saying? The women choose to answer questions.
So it's the way you ask questions. Are the questions leading to a point that could put embarrassment and shame on their side of the fence?
I would have to say,
but the way that he answered, the way that he questioned, what's the lady name, Miss Jessica? The way he questioned her, she kind of volunteered, as you noted in the last video. She kind of volunteered information. He asked her, "Well, how do you rate yourself?" So when once she provided the answer, then he was able to proceed. So,
right.
Yeah,
right. So basically, to me, he's not. My interpretation of what's going on, he is not. He's not presenting these women in a false light, and he's not doing it because, again, these women are volunteering information about themselves. You know what I'm saying?
Mm-hmm.
So,
let's talk about something. Number one, first of all,
Okay.
this is the United States of America. You can sue anyone for anything.
Ain't that right?
Okay, but
yeah, he's right. You can sue anyone for anything here in the United States of America. However, man, I think my bulb went out.
It has to fall within the causes of action.
Yeah. The case has to have merit.
Yeah. Which yeah.
You know, so I did want to point that out. All right, I'm gonna keep going.
But if you've been in court, you know there is a big difference between what you can have the court of public opinion, but
Absolutely.
in a court, it's about the law.
That's right.
And this is where it becomes laughable, because you have someone going around to platform after platform after platform, getting into altercations and disagreements with content creators, and then wanting to cry foul when she makes herself look foolish. Again, this happened back in the summer. And why?
Now, again, I want to clarify this for everyone. The individual that he's referring to is a different woman than Jessica, aka Miss Average at Best. All right, now let's keep going.
Why is all of this, and why is all this coming up now? Anybody can speculate, but let's be reasonable. I mean, let's be real. It's because of a lot of times people sue because they want easy money.
Yep.
Not going to necessarily get it because, again, it's about the law. And there's some terms that I'm going to throw out that people need to be aware with. Okay. Expectation of privacy. There is no reasonable expectation of privacy in public.
Now, let's stop right there. I can agree to what he's saying in part, that there's no reasonable expectation of privacy in the public. That is a term that is predicated on the Fourth Amendment. You know what I'm saying? So reasonable expectation of privacy tends to deal with governmental intrusions, is my point. Let's keep going.
There's no reasonable expectation of privacy on a public platform.
Right. And lawyers have said this. I've heard attorneys say this because I have attorneys working for me.
Exactly. So there's a difference between a law and a policy in your feelings.
There you go.
So
there you go.
Here's what I say. This is kind of funny in the same thing, because when you made the video about her doxing herself, she says this is against the law, but then I'm going to go out and proceed to do this and showed her. See, that's the thing. Why are you saying that your privacy was invaded when you're publicly she's been on your show what she's on made 3 or 4 different response videos to you.
Dude. Oh, yeah,
Things like
dude,
that.
honestly, I stopped paying attention to her after the second bit. I was like, dude, she's wasting my
Right,
time.
but the funny thing is, it's all around this. It all stems back to this whole viral video on YouTube.
Yep, that's
And
what
here's
it
the
is.
problem. Many women.
Now, when he's talking about the viral video on YouTube, he's referring to the video between he and Jessica, aka Miss Average at Best. All right.
See themselves as where their outcomes are going to be. That whole dying alone is really hitting women hard, because you can say 3 out of 4 of African American women marry in their lifetime, but every woman that heard that thought they would be one of the 4.
That's right, one of the 3
instead of the other 3. So this person running around, I'm this, I'm that, I'm high value, I got this and that, and it's like, well, why? If you got all this going on, what's the problem? And it's funny, but it's also kind of sad, because
it is.
It's like, lady, do you not realize you're making an utter idiot of yourself because no laws were broken?
Nope.
Now, I want to stop right there, because Kevin Samuels is saying that no laws were broken. Now, we're going to take a look at that to see whether any type of laws were broken. Now, keep in mind, right, that whenever a cause of action could possibly, whenever a cause of action could be a tort, right, for that tort to exist, that means that there are laws on the books in that particular state which give rise to that cause of action, which will be a tort. Did I explain that well, Rodney?
Yeah.
Okay.
Pretty much, unless you want to bring up a formal definition of the word tort, so that way they can completely understand. But you pretty much summed it up,
Right.
in a nutshell.
Right. I mean, I you know what, I could. All right, here we go. Tort. A tort is a wrongful act or an infringement of a right leading to civil legal liability. And that's a basic definition from Google. Now I'm taking a look at some of these other definitions. Let's see. Here go one right here. And from Britannica.com, tort in common law, civil law, and the vast majority of legal systems that derive from them, any instance of harmful behavior, such as a physical attack of one's, and then it goes on to say more. But the whole point is that a tort, right, is whenever a tort exists, there's a law that supports the tort existing in that jurisdiction. That's the point I'm trying to make. All right. So,
right.
All right. So let's go back to the video.
You're on YouTube, and then so let's go over some things. Let's go over some basic,
Okay.
here's some basic bullet points.
Okay.
So for the class at home,
Listen up.
look up case law. Case law.
Yes, we have case law. Yes, we do. Matter of fact, the case that we're going to take a look at, right, and we're going to view this again, it's going to be Miller versus Brooks. And this is from the Court of Appeals of North Carolina. This case is from 1996. So yes, we do have case law, and we're going to take a look at it. All right. Now let's keep going.
On things like this, and you'll find that they don't make it through court.
And let me explain to them. And I'm not a lawyer, okay? I went to paralegal school.
Now, let me stop right there. And I just want to deal with that statement that Kevin just made, that you have to look at case law. Let's go back to the case law. He says stuff like this do not make it through court. All right, now, make this clear for anyone who hasn't heard the first video. We take things like this and we view it objectively, meaning unbiased, right, and impartial, and no matter who the parties are. All right. Now, I made it clear in the first video that I am a fan of Kevin Samuels. However, right, we're dealing with this situation unbiased and impartial. So there is case law that exists. In this particular case, which is Miller versus Brooks, right, give rise to cause of action, right, for the allegations and claims that's being made by Jessica, aka Miss Average at Best. Now, let me scroll down and let me just get straight to the point. I'm gonna highlight this. In the Renwick, right? This is what the court is saying. It's saying the majority listed 4 types of privacy torts recognized in American jurisdictions. These are: number 1, appropriation of a plaintiff's name or likeness for a defendant's advantage. Now, this is the claim that these women call themselves making. This is the claim that they're saying. Now, as far as the actual cause of action that's being used in Jessica's, aka Miss Average at Best suit, we don't know. We don't know because we do not have a copy of it. All right. So again, if anybody,
let me cut in right quick.
Yes.
Kevin did mention, and this is hearsay, but he did mention that she said her privacy was violated. So that could be one type of cause of action by which the defenses that he's raising are legitimate. But based on what the young lady was talking about, that we can't identify, that was speaking on Miss Jessica's claim, stated what you're saying,
right?
Image and likeness. So Miss Jessica could have brought several different claims. You know what I'm saying? Invasion of privacy could be one, and using her likeness or image could be another, among other claims. Right. I just wanted to bring that up. So that's what I picked up off of what he said, that she said her privacy was invaded. So he must know something that we don't know. So let's just take it as that could be part of it coming from his side of the camp. And we're gonna also use what the other young lady was saying about the name and likeness. You know what I'm saying? So now we got at least two hearsay causes of action that we can deal with.
Right. Now, I will say this though, Rodney. I personally do believe, as far as Jessica, there in North Carolina, the appropriate cause of action that I think that she and her attorney should use will be appropriation of her name and likeness for Kevin Samuels' advantage. Plain and simple.
That's the only way she's gonna win.
I agree.
That's the only way she's gonna win. Anything less than that, she's gonna lose.
Right.
Unless Kevin lawyers are incompetent. You know, so again, we always say based on the lawyers' competencies and what deals they make, in my opinion, behind the scenes, what settlements, and things like that matter. But based on just law and what the causes of actions could and should be in order to win versus what were made or what could be made in order to help the defendant. Sometimes you can file a lawsuit and use the wrong cause of action and help the defendant.
Right. Yeah.
You know what I'm saying? Help to make it easier on the defendant because you didn't state the right claim. How do I know it? Because I've done it before. You know what I'm saying? If you don't state the right claim, or if you don't state the right arguments within your claim, or if you don't have or if you can't prove the elements within your claim, you lose, whether you're right or wrong. So one thing you always say, it's not about what's right, it's about what you can prove.
Yep.
So not
always
only
about what you can prove,
but you have to be able to prove it according to their rules.
Right. Facts. All right. So we wanted to point out that yes, there is case law that exists where she can have a legitimate cause of action. All right, I'm gonna go back to the video.
That won't get thrown out of court.
Right.
Kinda, and you guys know that story. What case law is it's a law that was put on the books that wasn't passed by legislation. So in other words, what was it? Roe v. Wade. That's probably one of the biggest, that's one of the greatest examples of case law in the history of American, the American judicial system.
All right, I'm gonna stop right there. I want to explain what case law is. Case law is
Thank
basically.
you, because he kind of. I'm glad you cut in because I didn't want to say nothing, but I'm glad you did. Go ahead.
Yeah, no, I was gonna say case law is basically judge-made law. That's what it is. Now, the judicial branch of our government has the duty to interpret laws. So how they interpret the law, what they interpret the law to mean is what it means. That's why case law is extremely important. Do you have anything to plug in? Right?
Yeah, and case law is the way as used in the United States, it almost establishes a tradition, right? And they base that tradition on their interpretation of the law, not only the law but facts. You know what I'm saying? So you can have a set of facts, whereas once the court make it in certain emphasis and determinations on those facts, you know, they'll lay out case law. See what Keith pulled up in that case law, he only highlighted one little sentence, but that case law is long. You know what I'm saying? It's a lot of information in that case law, and all of it can be used in law. You feel what I'm saying? So it's not just that one little piece that Keith brought up. That's why you have to read the entire case law. And once you read the entire case law, then you'll be able to take quotes and interpretations and sayings out of that case law and apply it to your case and either win or defend yourself properly.
Yes, indeed. Yes, indeed. In other words, precedent is what Rodney is saying. You know, precedent. All right, now let's keep going.
I don't like case law, but that's what we have.
Passed the
agreed.
You know, Noit Roba. What is it? Yeah, Noit Roba law. But after Roe v. Wade, then guess what? That made Roit Nova illegal. That's what that was. That's case law. Nobody passed it, but they found for the plaintiff in court. So that's case law.
So basically, can you imagine a world where, because you don't like how you came across on a TV broadcast or radio broadcast or something like that, you could sue for hurt feelings?
Right.
We would have no broadcast.
Right. We'd all be.
Well, let me say this. In America, anybody can sue. You know what I mean? Now, it don't mean you're going to win. Of course, your case have to have a proper cause of action. You got to have merit to what you're saying. You got to be able to prove the injury that happened. See, in order to have a legitimate lawsuit, they have something called case and controversy. You know what I'm saying? So you have to have an injury. It has to be some type of injury that exists, and you have to use the proper cause of action to prove that you were injured. So yeah, I mean, anybody can file a lawsuit. It don't mean you're going to win it though.
Right. I want to add something too, because he said that you think that people can sue if they go on a talk show or a TV show and their feelings get hurt. But what he's not talking about is before you go on a TV show, where your image, as far as your picture is reused, you're waiving that right. You know what I'm saying? And then I'm not gonna get ahead of the video because I saw the video prior. Right. But it's something else that he's gonna bring up that I want to talk about as well. But what he's saying, he's a little misguided in what he's saying, although what he's saying is true. Right. But what he's saying, the part that's true in his case is not, don't have to particularly, it doesn't specifically have to be about his case, but he believes that it is. You know what I'm saying? Because that statement that he made was that when you go on a TV show, you can't sue for getting embarrassed, but he's not discussing the underlying before you go and show your image and your image is used. You know what I'm saying? There's waivers, there's signed, there's compensation provided in order to use someone's likeness and that he's not talking about. But go ahead.
I agree. All right, let's keep going.
We broke, dude.
No. There would not be. Okay, how many people have gone onto a TV show or a radio show and have not had the best showing?
Happens all the time.
So in other words, but see where people try to get it. Well, you have to sign a media release. That's for a different set of circumstances. Social media is not governed the same way as stuff by the Article 230.
All right, let me stop right there, because what he's saying right there, that social media, right, which is YouTube, is governed differently than, let's say, like a commercial or advertisement with somebody going on television, right? Now, I have to say that I actually disagree with him concerning that. Now, I'm gonna go back to this case law. All right.
And I disagree with it too. And I also glad you stopped it right on the 230. That's what I didn't want to go ahead of.
Oh, gotcha.
And the Article 230, that's what I want to slightly address, but not too much. Go ahead.
Right. All right. What I want to point out is this part of this particular case. It says our Supreme Court has held that a right of privacy exists in North Carolina and has recognized the first type of privacy tort being invasion of privacy by the unauthorized appropriation of a plaintiff's photographic likeness for a defendant's advantage as part of an advertisement or commercial enterprise. Now, the reason I had to point this out is because there is a possibility that the courts in North Carolina will, right, determine that social media or of the likes of YouTube, right, where people actually, or content creators, are paid by views. So the amount of views they get, they actually receive revenue for that, right? There is a possibility that the courts in North Carolina would view that as a form of commercial enterprise. All right. So I wanted to make that very clear.
And let me just go into the case law again, like what you have highlighted.
Yes.
This little phrase can become law. This for people who, this to show people how to use case law. So if I was working for Miss Jessica, I would use this case law right here, 1996, which is prior to, I think the end. Was that prior to social media, 1996?
Yes, I believe YouTube came out. Well, I believe YouTube came out around the time, but yeah, for the most part.
Yes. So therefore they will have to. This could become a novel case, but this case right here will set precedent to sway it in her favor. That statement right there.
Yep.
Because it's unauthorized appropriation of plaintiff's photographic likeness for a defendant's advantage as part of an advertisement or commercial enterprise. See, that commercial enterprise is YouTube. You know what I'm saying?
Hey, Roddy, let me tell you, I may cut you off, but so many times, again, I'm making it clear. I'm a fan. You know, I want Kevin to succeed on the merits, but I can see how Jessica could win this because YouTube can't be considered a commercial enterprise. It can.
Yeah,
you know? And it's case law to support that it was a possible violation of her privacy. That's why we're pointing this out, because see, I want people to understand, like, again, Kevin and Donovan Sharpe are intelligent brothers and they are somewhat knowledgeable in what they're talking about in this video. However, there is case law that exists that supports a claim for privacy, for a violation of privacy, which would be her cause of action. You know what I'm saying?
Yeah. The case law can really smash them. You know what I'm saying? That's pretty much so it'll be like, if the case is brought properly by Miss Jessica and the other young lady, Kevin's defense would be it won't be successful. Right. You know, he'd be pretty much it'd almost be like if you're selling narcotics and you're selling drugs, right? And the and the alphabet soup, the FBI, DEA, all that, they kind of know what you're doing. So what they do, they start watching. So they watch you to a point to where that the feds ever come, and then you get a feeling somebody tip you on the inside, right? Mm-hmm. Maybe a couple months down the line, yeah, I think they watch you, be careful, and you just stop all business. You stop everything what they consider to be illegal, and you doing nothing for the next 2 or 3 months, but they still watching. So if they come get you off the streets, pick you up off the streets, it's gonna be hard to beat that case because they got a lot of law against you. You know what I'm saying? That's what. So in other words, you're gonna be wasting money. If they come get you, you wasting money by giving money to a defense attorney. You need to save that money for your commissary because you're going to the penalty box. If Miss Jessica bring her case properly, all the money that Kevin is defending on defense, he might as well save that money for his commissary or for his next business venture. You know what I'm saying? That's what I'm saying. It's equivalent to, it's the same. When the feds come get you off the streets, it's a slam dunk because they got so much on you, plus they gonna lie, that you might as well save your little chump change for your attorney who's gonna sell you out down the road after you just go through that 6 or 7 months of playing with the law to get to actually take your money, save that money for commissary. So in other words, That's why we want to see the lawsuit. If we see that lawsuit, I can determine, I'm sure you can too, Keith, whether or not a defense or he should settle. They call it in the civil terms, you settle the case.
Right.
And that's what the position that he would be in if she bring that case properly.
I agree.
And that case law that you just highlighted, that's all she needs.
Yeah.
Everything else is irrelevant. Trust me. But if her case is not properly and she bring her case in there with another thing that he was saying, because Kevin knows the case because the case was brought against him. He also spoke on about her feelings being hurt. So if Miss Jessica's lawsuit is couched in a manner where it suggests that her feelings is hurt, her privacy was invaded, and it's not talking about her image and likeness, but I believe it is based on what the other sister was speaking about in the first video. Kevin gonna have some issues with this unless he has a waiver. But he's saying that he doesn't have a waiver because he said earlier in this video right here that when you have to sign something, and so he feels that you don't have to sign anything because he feels as though YouTube is not part of
right.
being
He's saying
able to waive your rights.
He's saying social media.
So he's misguided
different
in a lot of legal aspects. Go ahead.
Right. He's saying social media is different than television. In other words, that's what he's saying. And I know he brought up Section 230. Section 230 does have civil liability claims, but what they're discussing, the whole issue right here, does not fall within the scope of that law. So to me, bringing up Section 230 is a waste of time, essentially.
Let me explain quickly why 230 has nothing to do with what this claim should be about. Because 230 is talking about like a radio show, like your voice. It's not talking about your image. Those are two separate things. It's your voice and it's your photographic likeness, aka image.
Well, let me say this though, Rodney. Section 230 does deal with social media. It does.
But
However,
it's talking about everything that I've seen in that, because I read 230. It's talking about your voice likeness. It's not speaking of your bring that joint out right quick. It's not talking about what I've seen. I didn't see it speak about your image. It's speaking about bring that joint. Not that. It's a section.
Yeah. It's I'm about to scroll down to it because it deals with like internet and interactive computer services, which is social media. But right here, it has a section for civil liability. And what they're discussing, or what the issue is between Jessica and Kevin Samuels, has nothing to do with the civil liability section within this law.
That's talking about it like sexual stuff, like crazy stuff that had nothing to do with them.
Yeah, violence,
I found
stuff
the section.
Like that.
I think I found a section because isn't this a U.S. code?
Yeah, it's I think it's
I found something in the
47.
statute of laws that talked about or maybe it wasn't this one that was talking about the voice. It didn't bring the image. The only image that they talk about is like lewd and sexual images. It's not talking about just your everyday organic image. If you talk about your everyday organic image, this doesn't protect it.
Right.
If you're talking about an image captured, you know what I'm saying? If your image was captured and a sexual image was captured, then that's what this law is talking about.
Right.
Is that what you're talking about?
Well, yeah, it deals with that. It deals with fighting words, violent words. It deals with all of that. It basically it makes it where the platform provider like YouTube wouldn't be responsible for civil liability if those things was posted by one of their users like that. That's why I'm like, yes. Section 230 has nothing to do with this whole dispute.
That's the protection for YouTube, not a protection for the but it doesn't say it's users as well. I thought
it's for users as well.
Okay,
but
yeah.
But we've been dealing with violation of privacy. These ladies have specifically been saying violation of privacy. You know what I'm saying? And I know that First Lady did say image and likeness. So she actually did use keywords.
Exactly. Those are keywords right there. There you go. And she could combine those causes of action to try to make more stick,
Right.
which
Right.
was the image and likeness, the invasion of privacy, the hurt my feelings. So you can bring up all those causes of action, and Kevin, just like his attorney, is doing the right thing, just attacking what they can overcome. Hey,
Right.
I can overcome this, her feelings being hurt. Hey, I can overcome her what's the other claim? The feelings hurt, and what's the other claim? Invasion of privacy.
Yeah, invasion of privacy. Yeah.
He can overcome those claims, so that's what his attorney probably would attack if those claims were added to her lawsuit.
Right.
But if that image claim is dangling out here over here, if it's dangling over here, they're gonna have to deal with it sooner or later. They may not deal with it in their response,
Right.
but they're gonna have to deal with it after their response.
I agree. All right. So let's keep going.
Right.
If you don't know what that means, you will. Next thing, legal basis. You have to have a legal basis in order well, you don't have to have a legal basis. You can sue for anything.
Sure.
But when you get in front of before you get in front of a judge, they're gonna say, what's the legal basis you're gonna sue on? What?
Let me stop right there. When he says legal basis, he means cause of action. Just to correct what he's saying, that because people, most people don't know. They just say legal basis.
That's right.
He's talking about cause of action, which is the reason why we in here.
Yeah, and it's best to just break it down like that, just for those. Many people may know, but maybe one or two who may not know, and what you just said would help.
Right.
What? Invasion of privacy? No, your privacy wasn't invaded.
Nope.
You use my
public
image
platform.
illegally. That's a policy.
Right.
It's not. That's not a law. What is the law that was broken?
Let me stop right there again.
Yeah, he's tripping.
Again, we just showed that there is case law to support. Now I'm gonna go back to it because repetition is.
Didn't you find the statute last time?
learn.
But that's in the first video. The statute that supports this case law.
Right here, the courts in North Carolina, and let me highlight this first part. It says in Renwick, the majority listed 4 types of privacy torts. Now, privacy torts are violation of privacy, y'all. Privacy torts.
And it's a cause of action. It's a private remedy.
Yes.
Torts is private. Status law is private. Things like that are private. Status, that's private. Constitution, tax law, administrative law, that's public law. So he's kind of missing public law and private. He doesn't understand these key words like privacy tort. Right. That's a privacy claim, cause of action, and what he's talking about, your legal basis. That's your AKA legal basis, privacy tort.
Yep.
But go ahead, my bad.
All right. Oh, no, you're fine. And the privacy tort will be appropriation of Jessica's name and likeness for Kevin Samuels' advantage. That would be the proper one. Now, in the first video that we done on this, we covered all 4 of them. So we're not covering all 4, y'all. We're just dealing with the first one. We already know that this is the only privacy tort that makes sense, that has any type of merit where she does have a case. So again, like we stated earlier in this video, if there's a tort that exists on the books, that means it's a law there that supports it. So this is law that we're dealing with. All right. I wanted to make that clear. You know what I'm saying, Rodney?
Absolutely.
All right, so let's keep going.
And
people break policies all the time. People don't go to jail for breaking policies. They go to jail for breaking
and the thing is, but here's where it gets tricky, because there can be a case made for modern law enforcement.
I just had to stop right here real quick, because matter of fact, let me go back a little bit. I want to make sure I heard what I think I heard, because I don't want to misquote. Let me just play it right here real quick.
What is the law that was broken? And
people break policies all the time. People don't go to jail for breaking policies. They go to jail.
Okay, I did hear what I thought I heard. Basically, he's saying people go to jail for breaking laws, not policies, right? Well, guess what? A privacy tort is a part of the law of that particular state. Now, all laws that get broken are not jailable. So some laws can be broken, but it doesn't mean that you're going to jail. So I did want to make
That's
that
the
point.
difference in criminal law and civil law.
Right.
You know, civil law, typically you don't go to jail for unless there's a jailable section attached to the civil law. Criminal law, it's a possibility. It's a possibility for you to go to the penalty box. Go ahead.
Well, and the thing is, but here's where it gets tricky, because there can be a case made for modern law enforcement enforcing policies versus law. There's an entire sector on YouTube called First Amendment Audits, where they go around and go like filming where they'll go around and like film in a public federal space.
Yeah.
And watch federal employees lose their mind, call the police to try to get them trespassed. Like filming in a post office is legal.
Wow.
It's legal.
Okay.
It's even posted on the postmaster's rules on the wall. It's called Article 7. But yet, go to your local post office and pull out your camera and start filming. And I can almost guarantee 99 out of 100 of you that either the woman behind the counter or somebody will tell you that you need my permission to record me, and that's against the law. No.
I want to stop right there real quick. He is 100% correct that going inside the post office and places like that is public property in a sense, so you can record. That is very true. And then I also agree with him that in most cases you will get an employee that try to tell you that you can't record, but that's right. That is public. All right.
It's not against the law. Well, you see that says no cell phone, this and that. That's a policy. A policy means something that you as an employer or somebody that works there. We don't have to deal with policy. We deal with law.
That's right.
You go into the post office and film, and there's hundreds of videos of.
Let me stop right there. Now, again, we're dealing with law too. We're dealing with law. So I got to go back to this. Let me go back to this again, because repetition is how we learn as humans. So I want to hit this home again. We're dealing with law, case law, right? Judge-made law, precedent, common law. It has many different terms, right? That the court says, right, that you do have what is called appropriation of a plaintiff's name, which would be Jessica's name, or likeness for a defendant's, which would be Kevin Samuels' advantage. That does exist. So in our opinion, here at the Power of Offense, Jessica does have a legitimate cause of action, right? Now, the challenge will be, right here, it says our Supreme Court has held that the right of privacy exists in North Carolina and has recognized the first type of privacy tort being invasion of privacy by the unauthorized appropriation of a plaintiff's, which would be Jessica's, photographic likeness for defendant's, Kevin Samuels' advantage as part of an advertisement or commercial enterprise. Now, the only reason I'm saying this is a challenge, right? It's because Jessica's attorney will have to prove that YouTube, right, which is a social media platform, is also a commercial enterprise. Now, I believe it can be done. I do. I don't even believe it's difficult to prove it. And the reason why I'm saying that is because YouTube generates revenue. You know, it's a little different than like a Facebook platform where you have your Facebook page up there, but they're not paying you for people viewing your Facebook page. See, YouTube actually pays us content creators for views. So that is a commercial enterprise. I just wanted to point that out. You have any comments to make on that, Rodney?
No, I totally agree.
Okay.
People calling the police, 911, because somebody pulled out their phone and started recording. Now, damn the 35 cameras that are around there. Forget everybody that's doing this. The thing is, this is freedom of speech. This is free speech, and it's freedom of the press. There is no expectation of privacy in public, especially in certain places. Now, if it's a personal business or something else like that, that's different. But in public,
say your house.
But that's your private space.
There
if you want privacy, go home and close the blinds.
There it is.
All right. So legal basis. So no laws are broken on YouTube. You volunteer to be on any video platform or whatever.
Now let me stop right there. He's right. You do volunteer to participate on a platform like on YouTube. So these women, right now, specifically, we're talking about Jessica, aka Miss Average at Best. She did choose, right? She did knowingly and willingly participate, right, in Kevin's broadcast. There is some truth to that, right? But again, it still doesn't mean that YouTube cannot be considered to be a commercial enterprise. So possibly a law was broken.
And even though she may have volunteered to be on a show, she may have volunteered to provide personal and private information about herself. She may have volunteered to everything that's Kevin saying, but she did not volunteer. Notice she waived her right for Kevin to profit off her likeness and image.
Right. I agree.
So that's like checkmate. So it depends on how they structure and bring their claim and how they defend it.
Right.
But if it was me, that was the only claim I would bring. So that way that'll take away a chunk of their response. You know what I'm saying? Because you know how they cherry pick and try to choose something to attack. The only thing that they can possibly prevail. Right. So yeah, that's it. So he just a little confused right now, but keep it moving.
Yeah. Yep. Let's keep it moving.
It's like going on to the Tonight Show.
Right.
And saying, you know, but here's the other thing.
Stop right there.
This whole thing about
just like going on the Tonight Show. If anyone ever been on the Tonight Show, they would know that there's waivers and signs or compensations, agreements, and everything you sign before you go on the Tonight Show. So he had to provide the waivers, the compensation, and everything that he provided for people to come on his talk show. Go ahead.
Good point. All right, I'm gonna go back just a tad bit. Let's go right there. All right.
And that's against the law. No, it's not against the law. Well, you see that says no cell phone, this and that. That's a policy. A policy means something that you as an employer or somebody that works there. We don't have to deal with policy. We deal with law.
That's right.
You go into the post office and film, and there's hundreds of videos of people calling the police, 911, because somebody pulled out their phone and started recording. Now, damn the 35 cameras that are around there. Forget everybody that's doing this. The thing is, this is freedom of speech. This is free speech, and it's freedom of the press. There is no expectation of privacy in public, especially in certain places. Now, if it's a personal business or something else like that, that's different. But in public
say your house.
But that's your private space.
There
if you want privacy, go home and close the blinds.
There it is.
All right. So legal basis. So no laws are broken on YouTube. You volunteer to be on any video platform or whatever. It's like going on to the Tonight Show.
Right.
And saying, you know, but here's the other thing.
Yeah. I mean, I actually wanted to hear that part again, Rodney, based upon what you said. Yeah, it's like going on Tonight Show, which will be a commercial enterprise. You know what I'm saying? Yeah. You know. All right, let's keep going.
This whole thing about videos and this and that, YouTube platforms, they can pull videos up, take them down. There are policies left and right, but no laws are broken. So here's the funny thing. Let's just say you end up in court. All right. Okay. You got to show a law that was broken.
Okay.
I agree with him right there. You know, you do end up in court. You do have to show a law that was broken. That would be your cause of action. You know what I mean? She actually has one. She has one that's legitimate. It's a privacy tort, violation of her privacy, the appropriation of her image and likeness for his advantage. You know what I mean? So it is a legitimate cause of action, or what he called legal basis, that exists. It is. And there's some evidence of merit to it. You know what I'm saying? If it can be proven that YouTube is a commercial enterprise.
Yeah, so, that's true.
Let's keep going.
Then even if you can show a law that was broken, you got to prove damages.
All right. I want to stop right there, Rodney. And I want to take people over to this article that we found that deals with North Carolina and the right of publicity law. All right, I want to read this. And the reason I want to read this is because he's talking about damages, right? Now, all right, let me start right here, y'all. Right here. All right, I'm gonna highlight where I'm starting at, the first sentence. All right. It says North Carolina does not provide a statutory basis for right of publicity claims. In 2009, the North Carolina legislature proposed but did not enact legislation that addressed the right of publicity. North Carolina appellate courts have only applied the misappropriation branch of the invasion of privacy tort in 2 cases. The Supreme Court of North Carolina last addressed misappropriation of image in 1938. It says in Flake versus Greensboro, right? Now, I want to show everyone something. So right here, we're going to discuss Flake versus Greensboro. Let me show y'all this. We were discussing Flake versus Greensboro right here. See, right here, when we're talking about, YouTube possibly being a commercial enterprise, we're actually talking about Flake, right? Flake versus Greensboro. All right. I just wanted to point that out in the case law because I want people to know, Rodney, like the stuff we read is all legitimate. So when we entertaining you all with our legal commentary, everything we read is legitimate and we read all facts. That's the stuff we deal with. So it says in Flake versus No, go ahead, say it again, Rodney.
I said that's the only thing you can deal with is facts.
Exactly. Now it says in Flake versus Greensboro News, and this case again was from 1938, the North Carolina Supreme Court recognized a cause of action for the unauthorized use of one's photograph or likeness in connection with an advertisement or other commercial enterprise. In Flake, the plaintiff brought suit on the basis of an advertisement published in a local newspaper that featured a picture of her dressed in a bathing suit. She showed evidence that the photograph was published in the instance without her consent. The court held that the unauthorized use of a plaintiff's photograph in connection with an advertisement or other commercial enterprise would give rise to a cause of action. That's a law, y'all. But that absent of showing special damages, only nominal and injunctive relief can be granted. So Jessica will have to show special damages. She would have to show how was she injured. I mean, how was she damaged from this injury? That's what she would have to show, right? And then if she doesn't show it, then her relief will be nominal, meaning it really wouldn't be that much of anything other than injunctive relief. Now, injunctive relief would be the court ordering Kevin to either blur her image or to completely remove it from YouTube permanently.
Yeah, go ahead.
No, go ahead, Rodney.
I was gonna say the special damages, she would have to get through discovery to get to how much she made off that video. Right. Because she was not, again, she's like an undisclosed investor. You know what I'm saying? Just because you're ignorant of your rights doesn't necessarily mean you waive them. So the special damage would be, I would phrase it to as what percentage of the amount he made off my image is owed to me. That's right. Special. That's the special damages she or her legal team will have to explain.
Right. Yep. And then it goes on and it says, and we're reading right here, it is not clear from the opinion in Flake whether the court treats the right of publicity as a property or privacy-based right. It says the court explicitly did not reach the question of whether First Amendment or newsworthiness defense might apply to such cause of action in other contexts. And then it goes on and it talks about this other case in Barr versus Southern Bell Telephone Company from 1972. A telephone company published a phone directory including an advertisement for the plaintiff's rug cleaning company. However, although the telephone company included the plaintiff's name, it used the likeness of an unrelated third party in connection with the plaintiff's name. So in other words, they confused the picture with plaintiff's name It says the plaintiff had signed an agreement that allowed for the commercial use of his image. However, the appellate court held that the publication of plaintiff's name in connection with the mistaken image exceeded the scope of this consent and might justify a finding of invasion of privacy. The decision implies that consent is a defense, but that if a publication exceeds the scope of consent, that the publication may be actionable. Now, I thought that was important to read also, Rodney, just because from the first video, I kept on stating that I believe implied consent exists. In some level of implied consent exists on the behalf of Jessica. You know, example, she called in demanding to receive Kevin's advice on a disagreement show. When Kevin agreed to give her the advice, Kevin said he's going to use this as a teaching lesson. Jessica said, okay. She never even asked what a reasonable and prudent person would ask is, what is a teaching lesson? She didn't say any of that. Kevin automatically, he popped her image up. Her camera feed was running so we could see the video of her. She already had her camera on. Kevin never asked her, to turn your camera on so I can see you. None of that. She already had her camera on. So obviously she wanted to be seen. Then she was dressed to impress. She looked her best, etc. She wanted to be seen. To me, that is all consent. That is all implied consent, right? So possibly Kevin might have a defense of consent, specifically implied consent, possibly.
Right. So let me read that, Johnny. It says, so this right here is talking about this barbell. This pretty much saying that there was a mistake in the image.
Right.
That was so the person whose image it really belonged to sued, not the person that gave consent with the name and image. But the fact that image was not the image that the person gave consent to use is it saying that the owner of the mistaken image was the one that sued.
No. It's the plaintiff is the one that signed the agreement for his image and name to be used in the publication, but they publish his name, but they publish someone else's image with his name like that.
That's what I'm saying. So who sued? The third party?
No. The guy that had the agreement for his image.
Which guy? The one that gave consent to the image, or the one that paid for the consent?
The one that gave consent to the image. It's just they used the wrong image. Yeah, see, they just used the wrong image.
Who provided that? That's probably too much. Who provided the wrong image? The person that's suing?
No, the defendant. It's like they had a mix-up. Is what I'm getting from it. Yeah.
Okay, so telephone company. Also, it was a mistake.
Yeah.
So the plaintiff was okay. Go ahead. Okay, I ain't gonna get too much in this one. So in other words, I just want to understand that the bar was the plaintiff who provided his name and image. So that's like Miss Jessica.
Yeah, that's like Jessica.
Her name and image to the telephone company, which would be Kevin Samuels, the YouTube.
Correct.
You know what I'm saying? So if Miss Jessica provided the name and likeness, we see that the plaintiff signed an agreement that allowed it. Where did Miss Jessica allow that consent with Mr. Kevin?
No, I see. I knew you was gonna point that. I agree with you. The plaintiff in this case had a explicit, or should I say, an express agreement with the defendant. Now, what I'm saying is, who
made the mistake? The first person, the
defendant. The defendant made a mistake. The
defendant put the wrong image, not the image that Barr gave him.
Correct. So what I'm saying is that implied consent from Jessica's actions, right, exists. You know what I mean? I'm trying to prove that it exists. So I'm trying to prove that because the article says consent. It doesn't say that it has to be express consent. You see what I'm saying? Meaning meaning in writing, y'all. For those who don't know what express mean, it means in writing. I'm saying that there's some level of implied consent there, and that could and obviously the decision implies that consent, which in Kevin's case would be implied consent, can be a defense to actually help him to overcome the suit against him by Jessica. That's what I'm trying to explain. Do you see where I'm getting at, Rodney?
Yeah. That'll help him with that. If she talked about invasion of privacy.
Right.
Yeah.
There you go. That's right.
You gotta prove damages. But let's get to the fun part. See, this is what people who watch Law and Order or Judge Judy and all these things tend to forget. They tend to forget this because they can hype each other up and tell each other stuff. If you've ever been to court, you understand that the people who tell the best story tend to lose in court because there's something called a countersuit.
That's right.
Frivolous.
Now, I'm gonna stop right there because yes, there is such thing as a countersuit. But again, in order for your countersuit to win on the merits, you have to state a legitimate, right, cause of action also, and you have to prove that you were injured in whatever that cause of action is. You got to prove your injury. So the same burden of proof that applies for the plaintiff, right, which would be Jessica, also would apply for Kevin Samuels, because once he filed a countersuit, he's taking a position as a plaintiff. So he has a burden of proof to prove his cause of action or his claims and allegations to be true also. So I wanted to make that clear.
Frivolous lawsuit, malicious prosecution. When you can show a pattern of behavior that where you actually were damaged by this person pursuing something frivolous, you can get treble damages plus attorney's fees. Like running around people calling straight men gay.
Right.
Now, I do agree with Kevin on that. You know what I mean? Because again, in that video that we watched, with our first video concerning this case, this lawsuit that Jessica filed against Kevin Samuels, we played a video that was done by TKO or by Tanya TKO, and there are content creators, right, that are making allegations or allegedly slandering Kevin for being gay. That's why he's saying that. Now, again, I don't know whether he's gay or not. He's saying that obviously they don't know, but yet still they're making these claims. So that would be slander. If they don't have proof that the man is gay, that is slander. Anything you want to plug on that, right?
Yeah, but as you said, but it goes back to what you said. He would have to prove how he was injured as a result of them calling him gay. And if they could prove that he is gay, then he wouldn't have a case. So he got to prove injury. Then they're gonna have to have proof that what they said was true. Go ahead.
Yeah, that's true.
And by the way, for the class, when he says treble damages, this means 3 times the amount that you asked for. So when the USFL sued the NFL back in 1982, the USFL won, but they were only awarded $3 because
Yes, Donovan Sharpe is correct that treble damages is 3 times damages.
They awarded the USFL $1, gave him $3, and then of course the USFL went bankrupt. So treble damages means 3 times.
Right. So even if you win what? What's the settlement? You win. You get awarded $10. But
all right,
then you can get countersued.
That's right.
See, this is where it starts to get trickery. You running around calling somebody gay, this or that, blah blah blah. Now there's some things I'm not going to talk about, but this is where actual law gets broken.
There you go. And I'm
gonna stop right there because Kevin is implying that actual law is broken for slander. This is, in other words, what he's saying. But keep in mind that actual law is still broken for violation of someone's privacy. So just as much merit as what he's saying that his countersuit would have with these women with these women stating that he's homosexual, right? They, or shall I say Jessica, aka Miss Average at best, has just as much merit in her claims and allegations that possibly Kevin violated her privacy. Now again, we showed it. We showed, right, case law. We showed case law. Again, the case is Miller versus Brooks. It's from 1996. This case was issued in the North Carolina Court of Appeals. And this is where the court talks about appropriation of a plaintiff's name and likeness for a defendant's advantage. So again, just as much as these women may have violated the law by slandering Kevin, right? He also possibly had violated the law by misappropriating these women's name and likeness for his advantage. That's the point I wanted to raise.
Right. So if that's the case, his lawsuit will be moot.
Right.
Counterclaim will be moot.
Right. Yep. So I mean, from what we can see, you know, Jessica does have what she's saying. What they're saying that she's suing Kevin for is merit to it. Is the point? There is merit that her privacy may have been violated, especially if she can prove that YouTube is a commercial enterprise. You know, and like we agreed to right now, I don't see where it's so difficult because YouTube generates revenue. Content creators do generate revenue on YouTube. So it's not like something like like Facebook or MySpace where people have profiles and people can view their profiles if it's set to public, but they don't receive any type of revenue for all the views that they receive of people viewing their profile. YouTube is a little different. You know, us content creators, we create content, people view it, and you get a certain amount of views, you receive compensation or revenue. So to me, that is a commercial enterprise, but we'll see how this play out. And again, right. And again, anyone that's listening to our videos, please, if you have access or if you have a copy of this lawsuit, again, please email us a copy to it. Our email will be in the description box of this video. Please send it to us ASAP. We would love to discuss the actual lawsuit. It would be awesome to see what was put in. It would be awesome for us to cover that, even to cover Kevin's response to her lawsuit. It would be fun. And as you can see, we bring the fire here at the Power of Offense. You know what I mean? We deal with facts. We have case law for your definitions. We do it all. So we entertain you with facts, right? Legal commentary from a layman's point of view, because we're laymen's, right? We laymen's that study and read the law. So that's pretty much it for this particular broadcast. And we'll catch you all on the next one. So please like, share, and subscribe.
Yeah, one thing Kevin Samuels better hope she has weak attorneys.
Right. Agreed. All right. Peace, y'all.
Peace.